You've now heard all of the evidence that either side has that they wish to present in this phase of the trial. It is now my responsibility to give to you the instructions of law that apply to the case. Again, I'm required to read them to you here in open court. However, again, we will make a copy of them available to you in the jury room to refer to during your deliberations. The very first few instructions are going to be the very detailed and very specific instructions guiding your deliberations in this phase of the trial. The rest of the instructions are going to be pretty much the general instructions that you already heard in the first phase of the trial with regard to evaluating evidence. So, as you know, this phase of the trial is to determine the defendant's penalty. The law provides for two possible penalties, either the death penalty or life in prison without the possibility of parole. You and you alone must decide which penalty the defendant will receive. You must disregard all of the instructions that I gave you earlier. I'm now going to give you a new set of instructions that apply only to this phase of the trial. Some of the instructions will be the same or similar to the instructions you heard before. However, follow only the instructions that I'm giving you now. In reaching your decision as to which penalty is the appropriate penalty, consider all of the evidence from the entire trial, both phases of the trial. Do not allow any bias, prejudice, or public opinion to influence your opinion in any way. As I indicated to you before, you must follow the law as I explain it to you, even if you disagree with the law. If you believe that any of the attorney's comments on the law is different than my instructions on the law, then of course you must disregard their comments and base your decision solely on my instructions. Obviously, you should pay careful attention to all of the instructions and consider them together as a whole. If any instruction seems to be repeated or stated in different ways, do not conclude that it is any more important than any other instruction or idea just because it seems to be repeated. Again, there may be some words or phrases used during the trial that have special legal meanings that may be different from their ordinary everyday meanings. If there are any such words or phrases that do have such special meanings, I will give you the special legal definitions, and then of course you will apply and follow those legal definitions. Any words or phrases that I do not define for you should be applied using their ordinary everyday meaning. Again, some of the instructions that I give to you may not apply depending on what you find to be the facts. Do not assume that just because I am giving a particular instruction that I am suggesting anything about the facts. I am not. After you have decided what the facts are, then follow the instructions that do apply to the facts as you determine the facts to be. In reaching your decision as to which penalty is the appropriate penalty, you must consider and weigh both the aggravating and mitigating circumstances or factors shown or demonstrated by the evidence. An aggravating circumstance or factor is any fact, condition, or event relating to the commission of the crime above and beyond the elements of the crime itself that increases the wrongfulness of the defendant's conduct or the enormity of the offense or the harmful impact of the crime. An aggravating circumstance may support a decision to impose the death penalty. A mitigating circumstance or factor is any fact, condition, or event that makes the death penalty less appropriate as a punishment, even though it does not constitute a defense or an excuse or justification for the crime. A mitigating circumstance is something that reduces the defendant's blameworthiness or otherwise supports a less severe punishment. Any mitigating circumstance may support a decision not to impose the death penalty. Under the law, you must consider, weigh, and be guided by specific factors of aggravation and mitigation where they are applicable. Some of the factors may be aggravating and some may be mitigating. I will give you a list of all of the appropriate factors. Some of these factors may not apply in this case. If you find there is no evidence of a factor, then you should disregard that factor. The factors in aggravation and mitigation for you to consider are as follows. Factor A, the circumstances of the crimes of which the defendant was convicted in this case, and any special circumstances that were found true. B, whether or not the defendant has engaged in violent criminal activity other than the crimes for which he was convicted in this case. Violent criminal activity is criminal activity involving the unlawful use, attempted use, or direct or implied threat to use force or violence against another person. Factor C, whether or not the defendant has been convicted of any prior felony other than the crimes of which he was convicted in this case. Factor D, whether the defendant was under the influence of an extreme mental or emotional disturbance when he committed the crimes of which he was convicted in this case. Factor E, whether the victim participated in the defendant's homicidal conduct or consented to the homicidal act. Factor F, whether the defendant reasonably believed that circumstances morally justified or extenuated his conduct in committing the crimes of which he was convicted in this case. Factor G, whether at the time of the murder the defendant acted under extreme duress or under the substantial domination of another person. H, whether at the time of the offense the defendant's capacity to appreciate the criminality of his conduct or to follow the requirements of the law was impaired as a result of any mental disease, defect, or intoxication. Factor I, the defendant's age at the time of the crimes of which he was convicted in this case. Factor J, whether the defendant was an accomplice to the murder and his participation in the murder was relatively minor. Factor K, any other circumstance, whether related to these charges or not, that lessens the gravity of the crimes, even though the circumstance is not a legal excuse or justification or defense. These circumstances may include sympathy or compassion for the defendant, or any lingering doubt you may have regarding his guilt, or anything else you consider to be a mitigating factor, regardless of whether it is one of the specific factors listed that I just gave you. Do not consider the absence of a mitigating factor as an aggravating factor. You may not consider as an aggravating factor anything other than the specific factors contained in the list that I just gave you. You must not take into account any other facts or circumstances as a basis for imposing the death penalty. If a fact is both a special circumstance and also a circumstance of the crime, you may consider that fact only once as an aggravating factor in your weighing process. In other words, do not double count that fact simply because it is both a special circumstance and a circumstance of the crime. You may consider sympathy or compassion for the defendant. However, you may not let sympathy for the defendant's family influence your decision. However, you may consider evidence about the impact the defendant's execution would have on his family if that evidence demonstrates some positive quality of the defendant's background or character. In order to be eligible to receive the penalty of death or life in prison without the possibility of parole, the defendant must have been convicted of first-degree murder and a special circumstance must have been found true. Each individual juror may consider any lingering or residual doubt you might have regarding whether the defendant is guilty of first-degree murder as an additional circumstance and mitigation in determining the appropriate penalty. Any lingering doubt you may entertain on the question of guilt may be considered by you in determining the appropriate penalty. A lingering doubt is defined as any doubt, however slight, which is not sufficient to create in your mind a reasonable doubt, but yet leaving a lingering or residual doubt about the question of the defendant's guilt. If there is such a lingering doubt, you may consider that as a mitigating factor in determining the appropriate penalty and helping you make your choice of penalty. In deciding whether life imprisonment without the possibility of parole or the death penalty is the appropriate punishment, you may not consider either the deterrent or non-deterrent effect or the cost of either punishment, nor are you to permit these issues to enter into your deliberations in any way. As I indicated to you, you have the sole responsibility to decide which penalty the defendant will receive. You must consider the arguments of the attorneys and all the evidence presented during both phases of the trial. In reaching your decision, you must consider, take into account, and be guided by the aggravating and mitigating circumstances that I've just given you. Each of you is free to assign whatever moral or sympathetic value you find appropriate to each individual factor and to all of the factors together as a whole. Do not simply count the number of aggravating and mitigating factors and then decide based on the higher number alone. Rather, you should consider the relative or combined weight or importance of the factors and evaluate them in terms of their relative convincing force on the question of punishment to you. Each of you must decide for yourself whether aggravating or mitigating factors exist. You do not all need to agree whether such factors exist. If any juror individually concludes that either an aggravating factor or a mitigating factor exists, that juror may give that factor whatever weight he or she believes is appropriate in determining the appropriate penalty. Determine which penalty is appropriate and justified by considering all of the evidence and the totality of all of the aggravating and mitigating circumstances. Even without any mitigating circumstances, you may decide that the aggravating circumstances are not substantial enough to warrant death. In order to return a judgment of death, each of you must be persuaded that the aggravating circumstances both outweigh the mitigating circumstances and also are so substantial in comparison to the mitigating circumstances that a sentence of death is appropriate and justified. In making your decision about penalty, you must assume that the penalty you impose, whether it be death or life in prison without the possibility of parole, will be carried out. In order to return a verdict of either death or life in prison without the possibility of parole, all 12 jurors must agree to the verdict. A defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people The defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence. Do not consider for any reason at all the fact that Mr. Merritt did not testify. Do not discuss that fact during your deliberations, and do not let it influence your decision in any way. The rest of the instructions are some of the general instructions that I had given you previously, but let me go over them again now. Just a reminder not to use any computers, cell phones, internet, social media for any research. Do not investigate the facts or the law. Do not do any research regarding the case on your own or as a group. Do not conduct any tests or experiments or visit the scene of any of the events involved in the case. Reminder about your notebooks. You can use your notes during your deliberations. Your notes are only for that individual juror's own use in refreshing their recollection of the evidence during the trial. Please keep in mind that anyone's notes can be inaccurate or incomplete, just as someone's memory can be inaccurate or incomplete. If there is a disagreement about any of the testimony or any other evidence at trial, you can ask the reporter, find that part of the testimony, and read it back to you. And in that event, of course, the court reporter's official record must guide your deliberations rather than your notes or your memory. You must accept the court reporter's record as accurate. Reminder not to remove your notes from the jury room. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you that you can consider as evidence. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys can discuss the case, but their remarks are not evidence. Also, the attorney's questions are not evidence. Only the witness's answers are evidence. The attorney's questions are significant only if they help you to understand the witness's answers. Do not assume that something is true just because one of the attorneys asked a question that suggested that it might be true. During the trial, the attorneys may have objected to questions and moved to strike answers given by the witnesses. I rule on those objections according to the law. If I sustain an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything that you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. During the trial, you were told that the people and the defense have agreed or stipulated to certain facts. This means that they both accept those facts as true. Because there is no dispute about those facts, you also must accept any stipulations as to facts as true. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if witnesses testify that they saw people coming into the courthouse wearing raincoats and carrying umbrellas covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it must be raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state, and the acts necessary to a conviction. Neither is entitled to any more weight than the other, neither is more reliable than the other. You must decide whether any fact and issue has been proved based upon all of the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find a defendant guilty has been proved, you must be convinced that people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject unreasonable conclusions. Again, you alone are the judges of the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of the witnesses by the same standards, setting aside any bias or prejudices that you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of their testimony. Among some of the factors that you may consider in evaluating a witness's credibility are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, or any personal relationship with someone involved in the case, or any personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with their testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence in the case tend to prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful about anything? Do not automatically reject testimony just because of some inconsistencies or conflicts. Rather, you should consider whether those differences are important or not. People sometimes honestly forget things, or honestly make mistakes about what they do remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness's testimony that they no longer remember something, that testimony then is inconsistent with their earlier statement on the subject. If you decide that any witness deliberately lied about something significant in the case, you should consider not believing anything that that witness said. On the other hand, if you think that the witness did lie about some things, but nevertheless did still tell the truth about others, you may simply accept the part that you think is true and ignore the rest. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of any single witness can prove any fact. Of course, before you conclude that the testimony of a single witness does prove a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and then accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or because of a desire to favor one side as against the other. What is important is whether the testimony or the evidence convinces you, not just the number of witnesses who testified on a certain point. During the trial, certain evidence was admitted for a limited purpose. You're again reminded to consider that evidence only for that limited purpose. You have heard evidence of statements that some of the witnesses may have made before the trial. If you decide that the witness made those earlier statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Some witnesses were allowed to testify as experts and to give expert opinions. You must consider those opinions, but you are not required to accept them to be true or correct. The meaning and importance of any opinion is up to you to decide. In evaluating the believability of an expert witness, follow the instructions about believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching their opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find to be unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and then to give an opinion based upon those assumed facts. It is up to you to decide whether those assumed facts in such a question have been proven or established by the evidence. If you conclude that any of those assumed facts are not true or have not been established by the evidence, you should consider the effect of that on the expert's reliance on those facts in evaluating the expert's opinion. If expert witnesses disagreed with one another, you should weigh each opinion against the other. You should examine the reasons given for each opinion and the facts or other matters upon which each witness relied. You may also compare the expert's qualifications. Some witnesses who were not testifying as an expert witness gave their opinions during the trial. You may, but are not required to accept those opinions as true or correct. You may give those opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters upon which their opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find to be unbelievable, unreasonable, or unsupported by the evidence. You have heard evidence that the defendant may have made oral or written statements before the trial or while court was not in session. You must decide whether the defendant made any of those statements, either in whole or in part. If you decide that the defendant did make such statements, then you can consider those statements along with all the other evidence in reaching your decision. It is up to you to decide how much importance to give to those statements. If a defendant tried to create false evidence or obtain false testimony, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt does not prove guilt by itself. You may rely on a defendant's out-of-court statements only if you first conclude that there is some other evidence that shows the charged crime was committed. The other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. The requirement of some other evidence does not apply to proving the identity of the person who committed the crime or the degree of the crime. If other evidence shows that the charged crime was committed, the identity of the person who committed it and the degree of the crime may be proved by the defendant's statements alone. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. There is, again, a concluding instruction. I will give that to you after the attorneys have had an opportunity to give their closing statements. We'll take a brief recess, about 10 or 15 minutes before the attorneys begin their opening statements. Again, keep in mind the admonitions not to form or express any opinions about the case, not to discuss the case. We'll see everyone back in about 10 or 15 minutes.